Thank you, Samba Shivarao sir, for playing the songs for us. Thank you very much. Um, today's topic is intellectual property rights. What are intellectual property rights? That's intellectual property. What is an intellectual property? Intellectual property is a property that arises from a human intellect. Our intention to conduct this type of webinar on intellectual property rights is to encourage our students and faculty to come up with innovative ideas instead of memorizing the stuff in the books. We have to come up with the ideas for the welfare of our institution as well as the society. So in this regard, I request our beloved principal sir, who is a kind hearted well wisher of this institution and who always supports us and encourages us, motivates us. Sir, please give your opening remarks on this occasion. I welcome our cases Ratna Prasad Garu, principal.
Good afternoon, everyone. Thank you. Thank you, Ranjana, for inviting me. On behalf of the staff and students of this college, I welcome you all for this webinar. I also thank Mr. More sir for accepting our invitation and on the board today. It is very important topic. I too finger crossed to listen to him. Once again, I thank IKS is working very hard in our college to organize this sort of webinars to encourage our students to learn more topics and also our teaching fraternity to equip themselves.
I think the network issue is from my side.
Okay, am I audible, sir? Am I audible?
Yes, sir. Yes, sir. You are audible.
Okay.
Continue,
So
sir. Please.
I have to, thank you. Thanks a lot, Anna. Especially I thank IKS team members all working very hard and keeping pace with the changing times and bringing out good. And also, okay, I'm glad that more of our college students are participating in this webinar. It's a good practice, and I thank the IKS team for encouraging the students to participate in this sort of programs. And I hope definitely everyone will learn, because the previous topic is very hard to digest, and I too in the beginning in a perplexed mood that what is intellectual property like that. Now I will learn something. So I thank once again Dr. Kumar Maurya sir for accepting the invitation and on the board today. Thank you, sir. Thanks a lot on the staff and students. Thanks a lot for participating in this webinar. Now, may I request Amjad ma'am to take over.
Okay, sir. Thank you. Thank you very much for your supporting and kind words, sir. Our students are participating in a virtual room 121, sir. Around 50 students are there. So to save our data and energy, we are saving so much data. Okay, we made them sit in that room. Thank you, sir. Okay, thank you, sir. So I know a few things about intellectual properties, like there is an organization, World Intellectual Property Rights Organization, that headquarters are there in Geneva, Switzerland, and they conduct one international day for intellectual property rights on April 26th. We are going to conduct one more webinar on that day. So I request our students and staff to remember that. Now it's time for our lecture on intellectual property rights. I request Anuradha, Assistant Professor of Mathematics, to introduce our resource person, Arun sir. Welcome, ma'am.
Good afternoon, everyone. I, P. Anuradha, Assistant Professor of Mathematics. It's my immense pleasure to introduce our today's resource person, Dr. Arun Kumar Maurya, in this webinar. Dr. Arun Kumar Maurya is an Assistant Professor of Botany, Multanimal Modi College, Modi Nagar, Uttar Pradesh. His area of specializations are plant physiology, biochemistry, IPR laws, and environmental laws. He has also obtained LLM and LLM degrees from Delhi University. and PG Diploma in IPR and Environmental Laws from National Law School of India University, Bangalore. He has published 4 research articles, 3 books, 5 articles, 5 chapters, and 4 e-contents. He has more than 10 years of teaching experience in various colleges like Hansraj College, Delhi University, SDDP Khalsa College, Delhi University, Dhyan Singh College, Delhi University, and present Multanimal College, CCCS University. He has developed study material as a member and subject expert of biology for classes 11 and 12 of International Curriculum CBSE 1 of CESE New Delhi in 2012. He was the subject expert for preparation and updation of Botany Dictionary by Commissioner for Scientific and Technical Terminology MHRD, Government of India in 2015. He has developed e-content for botany subject in Department of Higher Education MHRD, Government of India project, National Mission on Education through Information and Communication Technology in association with Delhi University 2014. He was a reviewer for Grassland Journal and Journal of King Saud University. With this brief introduction, I request Dr. Arun Kumar Maurya, please share your knowledge on intellectual property rights for the participants gathered here. Thank you, sir. Thank you for accepting our invitation. Over to you, sir.
Thank you, ma'am. It's a nice introduction. Am I audible?
Yes, sir. It's sir. But some little.
Am I audible?
Yes, sir. But a little disturbance is there. You are audible. Some disturbance is this.
Okay. First of all, I would like to thank principal of your degree college and coordinator of IQAC who gave me opportunity to interact with you as well as the students. I am also thankful for your fraternity who is sitting, and I welcome for interaction so that we can increase our knowledge in this subject. I am also learner in this area because my core subject is botany. I am specialized in plant physiology. By choice, I have tried to learn some law in which I find that which area is good for us, especially biologists. I found intellectual property right is one of the area along with environmental law useful for biologists like me. So I have tried to build up some information, knowledge
Sir,
related to that.
excuse me,
And
sir. Your
I,
voice is breaking. Can you check your instrument or internet once, sir? Your voice is breaking continuously. Some disturbance is there, sir. We can't hear you properly. So check your internet or instrument, and
I,
you can use some
I
microphone.
so
Madam, it may be also good without video. Maybe.
Yes, sir. Yes, sir. Sometimes
may
without video, it's video.
shall I off my video?
Yes, sir. Yes, sir. You can. You
Okay.
can.
Okay.
If there is a problem.
How's now voice quality?
Yes, sir. It's clear. Very clear. Yes.
Okay. So I'm taking off my headphone. I
Okay, sir.
think that is quite okay. Okay. So once again, welcome. Today I have planned to discuss as a IQAC coordinator and your request came. I have tried to summarize the things in basic way where we can discuss what kind of intellectual property exists and protected through law in our country. So we will go one by one discussing basics of each type of intellectual property, and then in coming future you may organize more in-depth webinar where each intellectual property can be elaborated and discussed in detail. So for today, I will take it as a simplified conceptual level, and then few case studies we can see where the intellectual property right has benefited us. So I'll begin by sharing my presentation. Is it visible?
Yes, sir, it is visible.
Okay. So let's begin with some outline where we can see. First, we can see some introduction and what is the relevance of IP, and then some declaration at the national and international level, where as a matter of law, where these IP law have been taken, incorporated, where they exist in law, and how many types of laws have been made in our country to deal these intellectual property. So here, as we can see, we have copyright, patent, trademark, design, geographical indication, plant varieties, trade secret, integrated circuits, and traditional knowledge. These are some of the IP which are protected through their respective statutes or act. So these are just a framework, and we will go for some case study. And for students, especially graduate students, this intellectual property right has a very good avenue as a career. So I think students should concentrate on that also, and they can take away as a message or information where they can start a career, and that career is very useful financially as well as intellectually also. You can reach at very high level. So as we can see, we can start the intellectual property by discussing the country. This law, whatever law which protects intellectual property, is prevailing in India. We can discuss under these headings. We have diverse ecosystem in terms of ecological ecosystem. We have an industrial ecosystem. We have service sector. So in our country, we have diverse ecosystem. Apart from ecosystem, we have great biodiversity, bioresources. These are available in our forest, in our farmyard. Wherever we go, we get the biodiversity in terms of animal, in terms of plant, microbes, insects. We have great diversity, and due to that, we have been categorized one among 16 biodiversity centers. With this ecosystem and biodiversity, we have great knowledge associated with that. And this knowledge is basically flowing from generations, and it has been called as traditional knowledge. And these traditional knowledge possessed by individuals, communities, farmers, laborers, builders, whatsoever, so many stakeholders are there, and they possess these knowledge. We have created a lot of industrial products. We have also made so many artistic creativity like movies, painting, songs. So what are these? These are basically the creativity which are coming from the raw material which is existing in our country, and human minds are using for that creation. So we can say simply intellectual properties are basically nothing but is the creation of mind. Like we make the painting, we make the song, we make the toy, we make the engine. What are these? These are basically output of brain, human creativity, and this can be called as intellectual property. Now, if we go by the picture, where as I discussed, intellectual property is basically it is an output of human intelligence, creation, innovation. So, as we can see, these are the output which is coming from human intelligence. Now, this output is going to basically make certain product. But before the formation of product, whatever we create through our mind, it is intelligible. We cannot touch it. We can have an idea. That idea gets translated into certain product. By using technique, we create a product. So when we create a product, someone creates a product, the person should be rewarded. And that reward comes in terms of some financial value. So whatever you create, it has certain economic value. But if you leave it in the course of time, others can take, steal. So to protect your creation, law exists. So protect different type of IP like copyright, design, trademark, laws have been made. So if laws are existing, if someone is stealing your creation, suppose you have made a song, someone is stealing, you can approach court and you can enforce them that this person has stolen my creativity. So these IPs are basically legally enforceable. So till you hold that power to enforce in court of law, you have monopoly over that. But these creativity are not forever. You are given legal protection for certain years, and that varies with different type of IPs. We'll discuss later. So why it has been done? It has been done to incentivize you so that you create something. You get the some incentive. I'll get money. I'll get fame. So I will create something. So people have certain gravitational attraction to do that. And it is also incentive for investor also. Some biotechnology lab, they invest money, they bring human resource like PG student having knowledge in biotechnology, they hire them, they pay them, and they give assignment to do certain thing, and that thing comes out in the form of product. So it is incentive for investor, it is incentive for creator both. So when these things happen, it derives the economy. We create some product, we sell it, and we make money. This way, economic growth occurs. So these are some of the value, feature, traits of intellectual property. Why we should protect it. There may be debate like why the monopolization for this year, that year. That is another kind of thing. We can discuss that later. But it is somehow in the current situation of global economy has some value. That is why this subject, this area is getting popularized in today's scenario. So this is the diagrammatic presentation. What is the relevance of intellectual property? As you can see, it starts from innovation and creativity. When you create, you get right. Those rights are called as intellectual property rights. And these rights exist and they lead to technological and artistic development. And these development lead to GDP growth. GDP growth gets transformed and reaches to the people, and that leads to socio-economic development. And finally, we put some more money into research and development, and that research and development leads to further innovation and creativity. In this way, the cycle keep on moving and we keep on flourishing. So this is the relevance of intellectual property right in current scenario. Now, as we have understand that the intellectual property is basically nothing but it's a creativity of human being. So this creativity can be various types, and we can classify these creativity or intellectual property rights into two forms: on the basis of nature and on the basis of right. What is the nature of IP and what are the rights originate from these creativity? So on the basis of nature, we can divide all intellectual properties into two groups. One is artistic intellectual property right, and other is industrial intellectual property right. So in artistic intellectual property right, we keep two types. One is called as C and D. C is copyright and D is design. So suppose if the bottle has particular design, like parachute oil, the bottle, if you see the bottle, you can say this is the bottle of parachute coconut oil. So This IP is wasted in that. So you can see artistically there are two type of intellectual property, right? Copyright and design. And rest are having industrial importance. So the short forms are written PPDPSGI. So here P stands for patent, T for trademark, D for design. So design exists in both. TS is your trade secret, GI is your geographical indication. So in the industrial IP, you have these type of intellectual properties which are having industrial value. Now, if you divide by right, you can see the rights are individualistic right and rights as a community right. So individualistic, the patent, trademark, and copyright. These are the type of IP where individual gets right to monopolize it, to benefit it. Things are attached with that intellectual property right. But there are some IP which are not individualistic. They are given to community. So traditional knowledge and geographical indication. These are two type of IP which are given to community, not individuals. So on the basis of these nature and rights, we can divide like that. Uh, in very not in depth, but in a short form, we can see the Constitution of India, which is land of law of the land, from where all acts, all rules, everything comes. So we should also know where intellectual property right exist, or we can take off from there in our constitution. So in Article 51A, that is your duty. Duty says you have to develop scientific temper, humanism, spirit of inquiry, and reform.
Excuse me, sir.
Yes.
The slides are not moving, sir. We are still in the first slide. Are you in the first slide itself?
No, my slides are moving, ma'am.
No, actually, here we can't see the sir. We are in the first slide, and
Okay, I'm
and
sharing.
please use your earphones, sir. I think uh, once it's not clear, voice also it's not very clear. Some
Okay.
and try to use that earphones. And yes, now we can see the slide relevance of IP.
Whenever you have a problem, please let me know. Otherwise, I don't know what is happening on
Yes,
the.
sir. Yes, sir. Yes, sir. Okay. And check your voice, sir. Voice
Yes.
is also not clear.
Are you getting my slide?
Yes, sir. Yes, sir. Relevance of IP.
Yes.
Yes.
This I have taught.
Yes, sir. Can you make it full screen, sir? It's not in a full screen mode.
On my side, it's in full screen.
Okay.
I think the transmission is having some problem.
Yes, sir. Sure. True. Okay, sir. And are you using that earphones or some voice is breaking again?
I think network problem, ma'am.
Yes,
Probably there is a problem,
yes,
like
network problem also. We have network problem. I think. Akash.
Is it visible?
Yes, sir. It's visible.
So what slide is visible on the screen?
Yes, directive principles for the state.
Now Constitution of India.
Change
No.
it, sir. No, no change. So,
This Google link is having some problem. Now,
yeah, Constitution of India.
okay.
And sir,
And what about my voice?
can you please press F5 so that we can see it in full screen mode, sir? Try once.
Actually, in my computer, it's in full screen,
Okay.
and I have a PC screen. Let me extend.
Okay, sir. Okay, you continue, sir. Just take care of your voice and please continue, sir.
Okay. So,
Okay, sir.
so in our constitution, we can see it says under fundamental duty that every citizen has to develop the scientific temper, humanism, and spirit of inquiry and reform. So here we can see the constitution propels us or pushes to develop scientific temper, and this scientific temper leads to creativity, where we can create industrial IP or creative IPs. And when you create, you get certain rights. So under this, we have a right to freedom. We can carry out any profession, carry out any occupation, trade, or business. So these IP rights are associated with trade, business. So many things are originating through this Article 19. Now, these are your rights. What are the rights of state? So some of the rights which are listed under the directive principle of the state that are indirectly linked with the intellectual property right. So as we can see, Article 38 says promote the welfare of people. So these intellectual property rights which are legalized by the state for what purpose? For promoting the welfare of the people. So that the one who creates patent or makes the patent should not monopolize forever. So it is the state who has to promote the welfare of the people. Under Article 39, it again says the state has to make policies, and through those policies, the ownership and control of whatever material resource is to be distributed to serve the common good. So patent, copyright, whatever intellectual property rights, they should be done in that sense. And similarly, the operation of economic system does not result into the concentration of wealth. So that is why these intellectual property rights are given for certain years, not forever. Similarly, in Article 48, it also says that a state has to organize agriculture, animal husbandry on modern and scientific line. So we can see the biotechnology, pharmaceutical, these are the branches where we have to increase or develop on the modern and scientific lines so that we benefit and we reap the fruits for the welfare of the people. Similarly, as the ma'am was discussing that there is an institution WIPO for promoting the intellectual property right at global level. So which law allows us to enter into the WIPO? It is the Article 51. We can see here the state shall endeavor to foster respect for international law, treaty, obligation in dealing of organized people with one another. Through this, we become internationalized and we share, we participate, go for betterment of people of country as well as globe. And under seventh schedule, there are three lists: union list, state list, and concurrent list. Under union list, Article 49 is specifically given for intellectual property right, where certain subjects are kept on which union government can make the law. So these are the constitutional structure that talks about your IPR. Similarly, in United Nations, there is a human universal declaration on human right that also indirectly pushes for intellectual property right, and where it says is the Article 27 that says that you have a freedom to participate, share, and enjoy. And in the second part, you have a right to protect. So, right to protect what? Whatever you have a material interest resulting from any scientific, literary, or artistic production. So, if whatever you are creating through mind, it should be protected. So, under this declaration, you can protect your intellectual property right. So in India, we have these laws through which we protect our different type of intellectual property right, like patent, like Plant Variety, Biodiversity Act, Geographical Indication Act, Indian Copyright, Trademark, Design, and Contract Act. Contract Act is specifically, I'll tell, there are certain trade secret for which we don't have law. So we govern it through Contract Act, such as ट्रेड सीक्रेट जो हमारा कोका कोला होता है उसमें हम कितना प्रपोर्शन में शुगर और अदर इंग्रेडिएंट मिलाते हैं वो किसी को पता नहीं होता. So that is a secret. So this secret is protected under Indian Contract Act. So now let's go to the direct conceptual topics. So what is copyright? Copyright is basically a right originating on original ideas fixed in tangible form. Suppose if I have an idea of writing a particular type of novel and we do not write those ideas on paper, you are not going to get the right on your created material. So for copyright, one should fix his or her original ideas in a tangible form. So whatever is your idea, if you are fixing it, writing it, making a song, dance, whatever, you're doing something which is fixed, then you get the copyright. And I'll not explain these things. This we can discuss later. Or so this is the copyright, and we get the symbol of copyright like this, which is made here. The copyright is basically given for three categories of things. Category A, we can remember like this, L, D, and A. So literary work, dramatic work, musical work, and artistic work. So copyright is given for these four things, L, D, and A. Why I have separated these three categories? Because their protection limit time is different. So copyright is given for these ABC things. Literary, dramatic, musical, and artistic work is one category. And the second category is cinematic and sound recording. And third category is performance and broadcasting. So someone is performing on a stage.
Sir, slide is not changing again, sir. Same slide. Constitution of India.
So she also has the right to protect that things.
And please change the slides, sir.
Oh, ma'am, दिख रहा है?
We can see that the Constitution of India and IPR laws, sir. We are in the same slide now. His voice is also breaking.
I don't know what is the problem going on.
Yes.
Shall I continue?
Yes, sir. Continue. Please continue. Okay.
I don't know, ma'am. I'm really sorry. There is
Yes,
some
yes,
network.
yes, it was good. The PPT was good, but we can't see all the slides. The slides are very interesting and colorful. Mm.
I'll send it for your use. There is no issue.
Okay,
You can
sir.
share.
Okay, please share. I will
So,
share with the participants. Okay, sir.
so copyright is basically given for these three categories: literary, dramatic, musical, and artistic work, cinematic and sound recording, performance, and broadcasting. So these are the subject matter on which copyright is given. This is the basic thing which we have to see. Now, apart from this copyright, the protection to these copyrights are given in a differential manner. For example, for LDMA, literary, dramatic, musical, and artistic work. LDMA, it's someone has written a book, someone has made a drama, someone has created a music, someone has created some artistic work like created on jewelry. So if you create anything under this category, you will get 60-year product protection. So whatever you have created, your work will be protected for 60 years. And it starts from the death of the author. The person who creates these things is called as author, and it is protected for next 60 years after the death of the author. Now, in case of cinematographic film, sound recording, it is also given for 60 year. And this 60 year starts from date of publication. So for film and for sound recording, it is given for 60-year protection, but it starts from date of publication. That is very important. Apart from this, we have broadcasting rights and performance rights. So these two are also protected for differential years. Broadcasting rights are protected for 25 years. And it starts from the beginning of the calendar year following the year in which broadcast is made. And performers' rights are protected for 50 years. So we can see the copyright protection is not equal. It is differential in nature, different product, different protection. And one very important thing is associated with this. If someone is going to violate your right, whatever you have created, sound, music, book, if someone steals or violates, the protection is available through copyright law. And this protection is extraterritorial in nature. Rest other intellectual properties like patent, trademark, design, these are territorial in nature. Territorial means you cannot file case if someone is violating in Sri Lanka. But in case of copyright, if someone is violating in Sri Lanka, you can get the remedy. So copyright protections are extraterritorial in nature. But in case of patent, it is territorial in nature. You can file case in your country also. But in copyright, if someone is violating in Sri Lanka or USA, you can file the case also. So this is the second thing. In copyright, there is a concept of moral right also. Moral right means,
The voice is not clear, sir.
sir, I'm really very sorry. I don't know why. Actually,
No, sir.
the problem is,
It's clear now, sir. Actually,
The
previously it
voice is
was not
clear,
clear,
sir.
but it's clear, sir.
Now
No,
it is
continue.
clear, ma'am.
Yes, continue, sir. Continue. Actually, in the beginning it was not clear, but now it's clear, sir. Please continue, sir.
actually the farmer movement took place in near Delhi. So I think the quality of
Net,
internet flow
yes,
is something
yes.
problematic after
It
that.
was stopped, I think, there in that area. Yes. Yes, sir.
So
Sure.
apart from the copyright law also gives a right that is called a moral right. Moral right means I'll tell example. Suppose someone has made a painting, and that painting was kept in a particular place for display, and if the person who allowed to kept that painting at that particular place can shift, can remove the painting, but he is or she is not entitled to mutilate the painting, or the content of the creativity should not be changed in such a manner that creates different sense. So this right is called as moral right. The person who has created that can object that you are mutilating my work, so that work should be protected. So copyright not only gives the materialistic power to control the whatever you have created, it also gives the power or right. You can stop other person not to damage, distort, mutilate, or modify his created work. And that is basically called as moral right. And if someone is interested, they can read the judgment given by Supreme Court, Amarnath Sehgal versus Union of India. It's a very landmark judgment. And the second thing which we should know for copyright, like now in today's world, we know that the plagiarism and all those things are going on. The copyright is not at all, prohibiting the things. It gives some, right to use the other's work also. So if you are using it for fair purposes, for teaching, for enhancing knowledge, for sharing, you can bring it under fair use. So section 51 of the Copyright Act gives this power. So you can, the someone is interested, go and read the section 51. It's a long list of things which gives where you can use the created work, which will not lead to offense. And under this, there is a landmark judgment of Delhi University where a photocopier person was sitting outside the library. He was making so many copies of the books and selling to the students. So the like Elsevier, Orient Longman, and so many publishers, they filed a case against that photocopier person and asked the damage, and the damage was so high he was not able to pay. The case went into the Delhi High Court and then finally settled by Supreme Court. So finally they allowed for us that for use academic purposes, for sharing knowledge, enhancing the things, photocopy is allowed, but the benefit should not be reaped. It's a long judgment. The crux is like that. We cannot get the entire book photocopied, but for the purpose of teaching and distributing, circulating, knowledge enhancing, we can do certain amount of use of that. Similarly, the thing associated with copyright is known as plagiarism. So in case of plagiarism, we can see plagiarism is nothing but it's a kidnapping or abducting others' work, and we are saying that it's our work. So it is now a kind of uh, uh, offense, because University Grant Commission has issued a regulation on plagiarism in 2018, and they have laid down a broad definition of plagiarism, under which it says that it is an act of academic dishonesty and breach of ethics. It involves using someone else's work and saying it's on work. So we should take care of this issue while doing our academic work, academic and research work. Similarly, the second category of IP is called as patent. So patent is basically given for any invention, any invention. But to get the patent, that invention must, show or follow four things. कोई भी इन्वेंशन हो, उसको अगर आपको पेटेंट प्राप्त करना है तो आपको चार चीजों से गुजरना पड़ेगा. अगर वो चार चीजें प्रूव हो जाती हैं, इफ दैट फोर थिंग्स आर प्रूवन दैट इट इज प्रेजेंट इन योर इन्वेंशन, you will get the patent. So these four things are novelty, inventive step, capability of industrial application, and there is a section 3 in Indian Patent Act that list certain 15 exclusions. If your patent or invention, if your invention is not falling under those 15 exclusions, you are through with your invention to get the patent. So what is novelty? Novelty is new invention. It should not be anticipated, means it should not exist prior to your creation. And the novelty is tested on product and process. And it should involve inventive step and capability for industrial application. So to get patent, in a basic nutshell, any kind of invention is okay, but those inventions should test positive for these four criteria: novelty, inventive step, capability of industrial application, and shall not be excluded under section 3. So these are the tests for patent. And in India, we have an act, Indian Patent Act 1970, that governs the patent. And it's a long section based act. And this patent is protected territorially, means the law is only applicable to the India, not abroad. And this protects for 20 years. So whenever you file a patent, you'll get it for 20 years. And you will have to renew it every year by depositing requisite fees. So this is the basic of patent. So I'll not go because my time is, I think, will eat up discussing these things. So these are the some of the exclusions under section 3. There are certain cases, landmark cases for patent. If someone is interested, they can read it. The landmark case across globe is the Diamond versus Chakravarti. It is based on some biotechnological patent, and it's a landmark judgment of United States Supreme Court that simply says anything created or invented under the sun that is made by man is patentable. So if human mind is creating something which has a value, and if that value is not falling apart from those four tests: novelty, inventive step, capability of industrial application, and not excluded under section 3, will get the patent. So these are the four judgments which are very landmark judgment in the patent case. Now another IP is trademark. Trademark, as we can see, excuse me ma'am, the slides are visible?
No, sir.
No, sir. We are in the same slide, Constitution of India.
Oh. And voice?
Voice is clear, sir. It's clear.
Clear, sir.
Sorry sir, I can't do anything.
Next time,
Voice is clear, sir.
yes, voice is clear, sir. Next time we'll take your PPT and we'll present on behalf of you, actually.
Yes ma'am. So the trademark is basically, can I try once more to fix it?
Now it is changing, sir.
When I go for fixing it, it changes, but when I
Now we are in the next trademark.
Now it is trademark.
Yes, we are in the trademark slide.
now
Same trademark.
So there is some problem. So now you can see in the trademark, trademark is basically a symbol, a mark, which is used for identifying the goods or services. So basically, to get the trademark, a mark which is device, brand, label, name, sign, diagram, etc. These are basically can be used for trademark, and it should show two more things. One, the whatever you use, device, brand, label, it should be capable of graphical representation. It should not be vague. And the second thing, the capability of distinguishing goods and services. So whatever you are graphically representing, it should be able to distinguish goods and services. If they are having overlapping mark, then there will be possibility of confusion. So the consumer may get confused whose product is what. That is why the law on trademark exclusively and clearly, explicitly says whatever you are bringing for registration as a trademark, it should be graphically representable and it should be distinguishable from two different trademarks. So anything which is written here, you can use it as a trademark. Now, in this trademark, as the photographs is also showing, there are different type of hoarding, names, pictures. The protection for these trademarks are territorial in nature, and the trademark is protected only for 10 years. So we can see in patent, we get protection of 20 years. In copyright, we get protection of 60 years. In trademark, we get only the protection for 10 years. But one thing is very different from patent. In patent, we have to pay annually the fee, but here it is renewed indefinitely by paying requisite fee. So once we get registered and we keep paying the requisite fee in the patent office, and we can continue with the same trademark forever. So this is the difference and characteristic of trademark as an intellectual property right. Like McDonald has a unique kind of name, Apple, Window, Android. Now, similarly, the other IP is design. Now, conceptually, what is design as per law? So for design, we should have three things. It should be a feature. It should be a feature in the form of shape, pattern, and it should be applied on any article in 2D or 3D or both through industrial process in the finished article. So whatever shape, pattern is available, you can apply it to an article. Like suppose if I discuss with the parachute bottle. Parachute oil bottle is unique. It has a special shape. It has a special pattern, and it is applied industrially. The shape is given, and the finished product, if we see it from remote also, we can say that this is the bottle of parachute oil, and the product on which we are applying the particular design should appeal and solely judged by eye. तो अगर हम किसी का कोई प्रोडक्ट हमने एक बार डिजाइन कर लिया, it should be appealable also. It should be solely judged by eyes. So when we find all these character in a particular design, then it can be registered under Design Act. If the thing is not following these criterias, it should be not registered. So as per law, the design should be new, it should be applicable on article, it should appeal to eye. And one more thing, when we go for registration of design, whatever design you have brought for registration should not be prior published, meaning thereby someone has not applied the similar or identical thing in the patent or design office. If it is existing, we will not get the design. And as we have discussed, the design is having dual type of intellectual property. It is a artistic intellectual property because bottle has a special type of artistic flavor, and it has an industrial flavor also because the bottle has industrial application for filling the particular liquid, water, or whatever use we do. So this design intellectual property is having dual benefit or dual nature. In terms of protection, if we go and see, the design is protected for 10 years. So suppose if someone has created a mobile, it is protected only for the design, not the internal item. It is protected for 10 years and it can be extended for 5 more years, but not forever. So we can see that design is at max can go for protection only for 15 years. And why they have done it so? Because we know that the technology is changing, the designs are also inevitable to change, so that it can keep appealing to the people, and people must people shall purchase new things, so the market economy keep on going. So this way, the thing has to be remembered. It is maximum protection is only for 15 years, 10 plus 5. Similarly, integrated circuits which are used in mobile phone, TV, camera, television, wherever we use the integrated circuits, the protection is also available for their layout design, not the exact integrated circuit. The layout design is protected. So what shape and size or the what layout design has been given in a particular set of chip of mobile or computer is also protected. And for protection, 4 things are tested. One is called as originality. Second, it should not be published prior. Your layout should be distinctive, meaning thereby some other person also have not the similar or identical layout, and it should be capable of distinguishing. So it should be differentiable from others' layout. So when your material is showing these 4 criteria: originality, no prior existence, distinctiveness, and distinguishability, you will get the protection on layout design of integrated circuits. And here, protection is only available for 10 years. The next intellectual property is available for variety protection, plant variety. So every variety which is created by human being, not existing naturally, we cannot get protection on the naturally existing varieties. So whatever variety we create, suppose we have a BT cotton, we have the any rice variety which has been created by human being by hybridization and other process, we can get the protection. So whenever we file the protection in a particular platform under the Plant Variety Protection and Farmers' Right Act 2001, we get certificate that we have created this variety by the human intellectual capacity. So when we go to the office for protection of our plant variety, our created plant variety, what the office checks four things in your variety. One thing is called as novelty. Your variety should be novel. And second thing is distinctiveness. Your variety should be distinctive from other varieties. And third thing is uniformity. Your variety should perform uniform throughout the generation. When you sow the seed, next seed should come with the similar traits. And fourth thing is called as stability. Whatever character you have developed in your variety should be stable. So in short, what is tested? NDUS. NDUS. Novelty, distinctiveness, uniformity, and stability. When your created variety starts showing these four features called as requirement for registration, you can get registration on your plant variety. And when you get the plant variety protection, you can use it economically, because that variety which you have registered, you can, make more copies of those variety and you can sell it in the market and you can earn. So this protection is given for 18-year for tree and vines, 15-year for other crops. So there are differential time gaps, but for tree and vine, it is 18-year, and for other crops, it's a 15-year. So 15-year, you can sell your new variety. After that, your right will end. And very important thing is, taken care from this act is, under this act, traditional knowledge is protected. Say, for example, if someone is creating a new variety by taking the seed material from particular place, and that particular place is, the having the gene pool of wild relatives, which are protected, promoted, proliferated by the local people, local communities who have saved that. So whenever we obtain that the germplasm for our research purpose, whatever benefit we reap by selling these varieties, we shall give certain amount to these local people, because their traditional knowledge has saved those plant of wild relatives. And this is made mandatory to the people practicing the making of new plant variety in the lab or in other places. And this is called as basically benefit sharing mechanism. And for that, under this act, there is a gene fund is made. So whatever money comes through the selling these variety as a small share, the fund is made, and that fund gives the money to the person who has contributed through their traditional knowledge. And one more thing is that if the plant variety is having terminator technology, or the plant variety is having any kind of effect on environment, such varieties cannot be cannot be registered under the plant variety. And through this plant variety protection, breeders, farmers, communities, researchers, everybody gets benefited according to their share of participation. And it's very much clearly laid down in the Plant Variety Protection Act. And the last IP, which is the geographical indication. Geographical indication, roughly, if I say for understanding, is the, say, for example, Darjeeling tea, Madhubani painting, Makrana marble, by which the Taj Mahal is made. In Kerala, there is a Navara rice. So these are some of the examples of geographical indications. So geographical indication, as we have discussed previously, it is a kind of IP that is given, the rights are given to the community, not the individual, as it is given in the trademark copyright, etc. So in geographical indication, it is basically the thing, especially goods. Geographical indications are given only for goods. And what kind of goods? The three types of goods are considered. One is called as agricultural goods, natural goods, and manufactured. So when any good is originating from a particular place, having particular climate, particular skill, and having a special characteristic, is given a tag of geographical indication. So we have to remember any good which is coming from agricultural, natural, and manufactured form. These are the three forms which are considered. And if they have a special type of quality, special type of characteristic, and a special type of reputation with associated with geographical reason, the geographical indications are given. So what is the value of this? If something is brought under the geographical indication, for example, Darjeeling tea, it gets value, and the price increases. It gets the status. It gets the recognition. So it has a value, and this value is reaped by entire community of that area, not the individual. So this is the IP, which is community-based IP. So I have given the example of Darjeeling tea, Madhubani painting, Masrana marble. These are some of the examples of geographical indication. Now, with this, for today, I will summarize the one case where the intellectual property right has benefited, and it is a well-known case of Kani tribe case. Kani tribe is basically they are living in Western Ghat, Kerala, and they are indigenous tribe where they live for several generations. So what happened in December 1987, there was a scientist, Pushpakendan, Dr. Alpu Pushpakendan. He was the director of Jawaharlal Nehru Tropical Botanical Garden Research Institute in Kerala. So he visited there and he was carrying out ethnobotanical expedition. So while carrying out the ethnobotanical expedition, he took the help of local people, especially the Kani tribe people, because they were, known to the area, what material is found there, which plant is found there. So he took them in their ethnobotanical expedition. So what he saw, he felt tired while moving here and there in the hilly region. But the people of Kani tribe, they never felt tired. So he observed that the Kani tribe is using certain fruits and leaves of a particular plant. So when the expedition ended, he asked that why you were not tired and you were so live while entire expedition, but we used to find ourselves tired. So initially they did not disclose it, because in their tribe there is a person called as Palathi. Palathi is the headman of all the information of these kind of knowledge, traditional knowledge. So they go by their consent. But later on, after persuading, he come to know that there is a plant called as Arogya Pacha, and the botanical name of that plant is Trichopus jalanicus. So they were eating the seeds and leaves of those plants. So after that, the scientist brought some plants in their laboratory. They carried out the experiment and they isolated certain um, medicinal value material chemicals from them, and they commercialized it as a medicine. The name of the medicine was given Jeevani, and there was an industry through which the commercialization was brought, Arya Pharmacy. So whatever information after research is obtained, the patent was filed, and this patent was taken out by this company, and whatever money was brought from that company is shared with Kani tribe. So there's a license fee, royalty fee, all these money was obtained through this selling of the patent. The money was used for welfare of these people by opening the school, hospital, and whatever thing. They established a trust through which they received the money, and that money was used for their welfare. So here we can see that how intellectual property right helped reaping the benefit obtained from the traditional knowledge. So here traditional knowledge is converted into commercial value. So this is the one example which is very popular, and it has been given space in the WIPO website also. The details of this is given there. And it is also an example of bioprospecting, because by the expedition, they got certain information about these plants, and that they commercialize. And at the end, for students, I have, because my slide is not visible, but if they can listen, the intellectual property right laws are very useful. Any student who has completed the age of 21 and obtained degree in science, engineering, or technology, they can go for patent agent. In the patent office, patent agents are required, and these patent agents are basically filing the patent, and they can advocate their case in the patent office. So when you are reaching the 21 and you have obtained simply a degree in science, engineering, or technology, you are eligible. What you have to do, you have to just pass an exam which is conducted by the patent office and pay a particular fee which is prescribed by the patent office. If you qualify the exam, you are entitled to get the tag of patent agent. And patent agents are making a lot of money. You can be a good, earner. And after that, if you interested, you can do the LLB. You can become lawyer also. You can go and in depth in the patent area, patent, trademark, copyright in this area, and you can make your career in this. So with this, for today, I will end here. And in the next time, I think we can fix this problem. We can go more deeper.
So thank you very much, sir. Even though there was starting trouble, we did it well, I think. So you gave the information clearly about patents and trademarks and copyrights, and with some examples like parachute coconut oil, and like that Indus novelty, distinctiveness, uniformity, and stability. Good to remember and good to know all these things. And at the ending, you gave such a wonderful story about the Kali tribes from Kerala, and that bio projecting
Prospecting.
that yes. Yes, and arogya, some plant, what was the name of that
Arogya Pacha.
arogya pacha, and the botanical name, what is the botanical name of that?
Psychopus gelinicus.
Psychopus gelinicus.
Yes, ma'am.
Okay, thank you, and you gave some very useful and interesting information at the end, that our students, after completing 21 years age, and they have degree in science or engineering and technology, they can go for a patent agents. They have to pass an exam by patent office. So it was very useful, sir, that information.
Very simple exam.
Yes, yes, yes.
Yes.
So this type of information we need, sir, to encourage our students. And nowadays, from our entrepreneurs development cell, ED cell, we are coming with some startup ideas.
Yes.
we can use your this information for that. We can go for rights, that's patent rights. And you gave so much information like the period, renewal period, everything. So we can conduct one more webinar on this filing patents.
Yes. Yes.
So this
Definitely.
time we'll take care of this technical errors. And thank you very much, sir. Now I request Dr. Chinnappa Garu from Government Degree College, Palvansha, to give his opinion on this webinar. Sachinappa, sir, please welcome.
Principal sir of JDC.
GDC.
Principal.
Good evening, madam.
Good evening, sir.
So, once again, congratulations, our own college, SRN BGNR, principal and other team members. Recently, there are a number of webinars conducting in the first place, I think, in the state. So, 100% sure, madam. It is
Thank you,
accurate.
sir. Yeah.
So, any topic, any area, number one, dynamic IQAC coordinator, mainly. So once again, congratulations and thank you so much, my dear brother, Dr. KSS Ratan Prasad and his team. Thank you. Thank you so much.
Thank you very much, sir, for your friendly and encouraging, supporting words, and some cordial relation between two colleges. And you're an alumna of our college, alumnus of our college. So we treat that you are from our college itself. Thank you very much, sir. And any one of you can ask questions, or you can say your opinions
Yes.
within
Yes.
5 minutes. Yes, yes. Students or faculty can ask queries, or you can forward your doubts or queries to us. We'll share with our resource person, or you can type in our chat box here. So you can take time to think, and we'll share the PPT also. We request our resource person Arun sir to give his PPT to us. And now
Very
I
much.
Okay, thank you, sir. Now I request Dr. Chaitanya to propose vote of thanks.
Yes, ma'am. Thank you, ma'am. Good evening, one and all. Respected Principal, sir, Shri KSS Ratna Prasad Garu, our resource person for the day, Dr. Arun Kumar Maurya, sir, IQAC coordinator, Srimati Anjani, ma'am, uh, uh, Shri Chennappa, sir, principal of Palavancha Degree College, and all the participants. I'm very pleased to give away the vote of thanks for today's program. Firstly, I would like to thank our resource person from the bottom of our heart on behalf of our college, because with one single phone call, he accepted our invitation without any hesitation, because as I should admit that and acknowledge that I could come to know about Arun Kumar sir through my friend. And thank you so much, sir, for accepting the invitation and giving us and our students a bird's eye view of IPR and what are the basic things in IPR. As Anjani ma'am said, definitely we will have another session where we would know in detail about the filing of patents. So thank you, sir. Thank you very much. And
Thank you, ma'am. Thank you.
from behalf of our entire college, we thank you so much for giving your valuable time and the slides, because you started from the very basic of the constitution, how the law goes on, and what kind of types are there. And the most thing what I liked is, as you are also from botany background, you have chosen certain examples from the same background. That is more interesting for our students and for me also personally. So thank you so much, sir, for giving different examples from our own area where we can thrust upon more. So thank you so much, sir, once again. I thank our principal sir, Sri K.S. Ratna Prasad sir, for his constant support. I should stress upon the word constant because he is always, he always gives us that free hand to conduct the programs. And thank you so much, sir, for believing in us and giving us this support. Thank you so much, sir. Next, we thank Sri Channappa, sir, Principal, Palvancha Degree College, for attending the program and, as ma'am mentioned, for giving your kind words, sir. It is a boosting for us, definitely, because as a cordial relationship, it always gives us that support that our sister colleges or our friendly colleges are also attending. Thank you so much, sir, for being with us today. I thank Krishnaveni ma'am, Assistant Professor of Botany from Government Degree College, Women, Khammam. She attends all the programs what we conduct. That shows a keen interest to learn the subject. So thank you so much, ma'am. I thank our IQSC coordinator, ma'am, Anjani ma'am, for believing in me for the choice of the resource person for the third time in this year. Thank you, ma'am, for giving me a chance to introduce Dr. Arun Maurya, sir. Thank you so much, ma'am. I thank P. Anuradha, ma'am, Assistant Professor of Mathematics, for giving us the team spirit, the support what we need to have in a team. And my special thanks for Sambasirao, sir, Assistant Professor of Hindi, for always supporting us in, he always, we feel very comfortable that, okay, sir is there, now the program will be on time and it will be very precise. So thank you so much, sir, for giving us that kind of support. I thank Yaladri sir, TSKC mentor, for giving us the technical support in setting up the virtual classroom for today's session. So yesterday also we had a webinar for mushroom cultivation and sir extended his help. Thank you so much, sir. I thank all our students who have been here patiently because as I was discussing with Arun sir, this subject is very new for the UG students. In spite of that, our students were interested to listen. They at least came to know this, that IPR exists, and it is very much important in these days because most innovations are getting a lot of funding, and they can think in different dimensions. So thank you all students. I thank our college and AQSC coordinator ma'am for giving me this opportunity to propose the vote of thanks. Thank you once again.
Thank you, Dr. Chaitanya. Actually, Chaitanya ma'am, Assistant Professor of Botany and an active IQSC member, and she is world famous for her vote of thanks. She proved that today.
Thank you, ma'am. But once again, I would like to thank our resource person because
Yes.
Thank you,
because
ma'am.
we are meeting only online. Thank you. Thank you, sir. We would definitely would like to arrange another session for property rights and laws. Thank you.
Okay, thank you.
Thank
Thank
you.
you, everyone. And I thank especially S. Ramesh Garu, Commerce Department, for
Yes, ma'am.
encouraging IKC team to
Yes,
conduct
sir. Yes.
a webinar in IPR. Thank you, Ramesh, sir.
Madam, thank you very much. Thank you very
Okay.
much, ma'am, for
Okay,
accepting.
okay, sir. Okay. And all the participants, please fill the feedback form in the chat box and you will get e-certificates. And once again, I thank our resource person, Dr. Arun Kumar Maurya, sir, for his patience. And actually, I disturbed him many times for that voice and slides. Sorry, sir, but it was on behalf of our participants.
Network issue,
It
ma'am.
was my duty. Yes, yes. Thank you very much for understanding, sir. Thank you. Thank you, everyone. Let's call it a day. Bye.
Madam, Maurya sir is saying something, madam.
Sir, please welcome.
No, ma'am. I just
Yeah,
said thank you, everyone, for
Yes,
listening and
yes,
giving me opportunity. And it was nice talking to you all. We
yes,
are all in learning, so we will keep
yes,
improving
yes,
ourselves by learning so many things, whatever new
yes,
comes to us.
yes, sir.
Sir, Maurya sir, we will
Yes, sir.
send you certificates, sir. Sir, we will send you certificates, sir. Gratitude certificates.
Yeah,
Thank you,
sir.
sir. Thank you very much, sir.
Thank you.
Thank you, Sambashivara, sir, for final touchings. Bye.
Madam, shall we call it, madam? Okay. Nana, Yellarao. ఓకే ఓకే మేడం, ఫీడ్బ్యాక్ ఫామ్ చాట్ బాక్స్ లో ఉంది మేడం. ఇంకా నేను మళ్ళా గ్రూప్ లో కూడా పోస్ట్ చేస్తాను. ప్లీజ్ లీవ్, అందరూ ఒకరి తర్వాత ఒకరు వెళ్ళిపోండి మేడం. Please left the group, please.